Hi, very good morning. This is a Supreme Court judgment under the Insolvency and Bankruptcy Code. Interesting judgment. The citation is Visa Coke Limited versus Mesco Kalinga Steel Limited. Facts of the case, no need for getting into the entire facts. Simply put, operational creditor sent notice to corporate debtor. So somebody took money, he failed to pay the money. So operational creditor sent notice to the corporate debtor. Notice was sent to three key managerial persons, indicating their designation and the company name. No notice was sent to the corporate debtor, that is in the name of the company. Notice was not sent in the name of the company. The question before the Supreme Court was whether the notice served by the operational creditor upon the key managerial persons of corporate debtor at the registered office of the company, whether this constitutes valid service of the statutory demand notice under section 8 of the IBC, that is Insolvency and Bankruptcy Code, hereafter IBC, so as to maintain a section 9 petition for initiation of corporate insolvency resolution plan against the corporate debtor, CIRP. NCLT and the NCLAT said that the notice to key managerial persons is not a valid notice under section 8. So they dismissed the application filed under section 9. Matter went to Supreme Court. Supreme Court said on a perusal of section 9, the key requirements for filing the petition under section 9 for corporate insolvency, these are the following requirements. Supreme Court said 4 requirements. One is, first, demand notice in Form 3. It must be served on the corporate debtor. First requirement. Second, after 10 days or within 10 days, not after, within 10 days, if the payment is not made or if there is no valid dispute, then the application under section 9 can be filed. Third, application must be filed in Form 5 as prescribed by the adjudicating authority rules. Then 4, supporting evidence must be annexed. It could be invoice, bank statement or written contracts. That must be annexed. These are the 4 requirements for filing section 9 application. Supreme Court also saw the rules, Rule 5, 2A and B of the adjudicating authority rules. Under that rules, a demand notice under section 8 can be addressed and delivered to the corporate debtor through its KMP. That is what the Supreme Court says in the judgment. Little later in the comment section, we will see this aspect. So as per Supreme Court, as per Rule 5, 2A and B of the adjudicating authority rules, demand notice under section 8 can be addressed and delivered to the corporate debtor through its KMP. Then Supreme Court looked into the demand notice in Form 3 issued by the operational creditor. Demand notice was addressed in the names of the KMP, that we have already said, and delivered at the registered office of the company, that is the corporate debtor. Subject of the notice clearly said demand notice or invoice was issued demanding payment in respect of unpaid operational debt due from the corporate debtor. It also said that if the corporate debtor failed to pay the operational debt within 10 days from the date of receipt of notice, CIRP will be initiated. Supreme Court on seeing this said that it is very clear. Notice was issued to the corporate debtor in respect of the operational debt due and payable by them. Hence, it cannot be said that operational creditor did not comply with the statutory requirement of sending demand notice in Form 3 to the corporate debtor. Supreme Court relies on a decision in the case of Rajneesh Agarwal versus Amit Balla, that is under the Negotiable Instruments Act, where Supreme Court said a notice issued to director is a notice to the company. So Supreme Court also said a substantive right cannot be allowed to be defeated merely on the grounds of technicalities. That is a correct position. The substantive right cannot be allowed to be defeated merely on the grounds of technicalities. On the above reason, Supreme Court set aside the orders of NCLT and NCLAT and directed NCLT to admit the Section 9 application. So that is the judgment. That means even if you serve the notice on the key managerial personnel at the registered office of the company demanding payment within 10 days, then it constitutes a valid notice as per the Supreme Court judgment. My comments. I have a few doubts. I am expressing them and just leave it at that. I had a look at Rule 52A and B of the adjudicatory rules, which reads as below. Demand notice by operational creditor. 1. An operational creditor shall deliver to the corporate debtor the following documents, namely a demand notice in Form 3 or B, a copy of an invoice attached with the notice in Form 4. This is Rule 5.1. Now the important rule 5.2a and B. 5.2a, the demand notice, 5.2 starts with this. The demand notice or the copy of the invoice demanding payment referred to in subsection 2 of section 8 of the code may be delivered to the corporate debtor. Then A. A says at the registered office by hand, registered post or speed post with acknowledgement due. Then there is a colon, after that R, that is it is separated. B. So 5.2a says it can be delivered to the corporate debtor at the registered office by hand, registered post or speed post with acknowledgement due. Or then after putting R, B says by electronic mail service to a whole-time director or designated partner or key managerial person, if any, of the corporate debtor. That means legislature has clearly bifurcated these two types of service. One is A says at the registered office by hand, registered post or speed post with acknowledgement due. There they have not said even if it is addressed in the name of a key managerial personnel. Then when it comes to electronic mail service, they clearly say if you address it to the whole-time director or designated partner or key managerial personnel, then it is served on the corporate debtor. Suppose if the legislature wanted to say that if it is served on the key managerial personnel in any way, that is enough, then there is no need for bifurcation of A and B. Separately, they did not have said this. They should have said registered post, speed post, acknowledgement due by electronic mail, etc., whether served on the company or on the whole-time director or key managerial personnel. They could have said that, but they did not say. They make a clear bifurcation. First is A, they are clearly saying registered post, etc., colon, or, and then B, they are saying electronic mail to the whole-time director. So this provision, this rule has not been extracted in the judgment. My humble submission is whether this has been seen by the Supreme Court, and Supreme Court says in spite of this clear bifurcation that even then the notice issued by speed post or registered post, even in the name of the key managerial person, that is also a valid service. Because in the judgment also, Supreme Court has not said whether the notice has been served by registered post, speed post, or by electronic mail. That portion is clearly absent. Why I am saying this is tomorrow there could be another petition before the Supreme Court, another appeal before the Supreme Court, saying that so this aspect has not been considered by the Supreme Court, it should be considered. There could be a different view also. So Supreme Court, because it's the highest court, it should have looked into this provision, extracted this provision, and said, in spite of this provision being there, we are saying no, it is even if it is served on the KMP, it is served on the company. That is my first doubt. Second doubt, Supreme Court relies on a judgment in the case of Negotiable Instruments Act, wherein Supreme Court said the service on the director is also a service on the company. My doubt is Section 141 of the Negotiable Instruments Act says, if person committing an offence is a company, then every person who at the time of the offence, when it was committed, was in charge of and was responsible to the company for the conduct of the business of the company as well as the company. So both company and the persons responsible for the company, they shall be deemed to be guilty of the offence and shall be liable to be proceeded against. I will stop with that. It is going. So in that case, in the case of a check bouncing, the act clearly says the offence is committed both by the company and also by the KMPs, whoever is in charge. So in that case, if notice is issued to the KMP, then it is natural that notice issued to KMP is also a notice issued to the company. But in this case, in IBC, when the notice is issued to KMP, because there is no, it is not saying that both are guilty of the offence of non-payment or guilty of non-payment of the debt due by the company. It only says company. In that case also, will this provision under the Negotiable Instruments Act, will it apply to the IBC is the second question, because there is no pari materia provision under the Negotiable Instruments Act and also under the this thing. That is my second doubt. Third is, I do agree with the Supreme Court in the sense, who am I to agree or disagree? I guess. Only I am expressing my thoughts on this, because Supreme Court says that what the Supreme Court said was the substantive right cannot be allowed to be defeated on the ground of technicalities. I do agree, because company is a artificial judicial person. It cannot function on its own. Naturally, one of the directors has to open the letters or notices and then see it. On that ground, I agree, but these two aspects also should also have been considered by the Supreme Court. Is my humble view. Thank you very much. Have a great and wonderful day. Bye.